Hi, how are you? Do you hear me? Please, or write to me. Do you? Thank you. Thank you very much. Okay. So if you can give or share screen, I will share my presentation. Thank you very much. Okay. Okay, so now I think you hear me and everything is okay. I can start. Okay. So I will start, and if you have a problem, something to tell me, I have 20 minutes. Thank you very much. Okay. So good day for everyone, and I'm very happy to be here, very honored to be in the annual symposium. I'm very happy to be here every year to meet all of you. So my issue today is extramarital relationships and their theoretical rationales for the joint property rules. So extramarital relationships under a joint property regime. The Court of Appeal draw ruling handed down at the end of 1970s serves as the primary basis for excluding consideration of extramarital relationships from family property distribution in Israel. What does it say? Abandoning the house or adultery might create a rift between spouses and in this way terminate the sharing of property, but the spouses are not retroactively punished by taking away joint property rights. It gives no reason why extramarital relationships should not be considered in property distribution. However, with respect to external and personal property, means when spouse bring him before the marriage, owned by one spouse prior to the couple's relationships, one finds an opposite rulings. In the High Court of Justice, anonymous case, an opinion given by Chief Justice Barak determined that ongoing betrayal undermines the basis for harmony and therefore prevented the application of joint property principles to external property. However, it did not cancel the joint rights acquired during the marriage. Balancing resources. In 1973, the property relations law was enacted in Israel. This system creates an absolute separation of property throughout the entire marriage. The property is divided between the spouses only upon death of one spouse or in the event of divorce or a year before in some circumstances. Section 8.2 of this law provides that if a court finds a special circumstances, it is authorized to determine that the balancing of the property value not be half and half, but rather some other proportion. In the High Court of Justice, anonymous case, the court considered whether extramarital relationships are special circumstances. The rabbinical court held that adultery is included in special circumstances and refused to distribute the family property. The wife petitioned the Israel Supreme Court, which relied upon the draw ruling and decided to reverse the decision of the rabbinical court. It says like this: the dissolution of every marriage has broad economic impacts. The need to build another home is not unique only to couples whose marriage broke up because of adultery. Let's see if you're writing me something. Okay, great. Thank you, thank you. So I will share another screen. Thank you. So the wife petitioned to the Israel Supreme Court, which relied upon the draw ruling and decided to reverse the decisions of the rabbinical court. The dissolution of every marriage has broad economic impacts. The need to build another home is not unique only to couples whose marriage broke up because of adultery. Another argument was made by Judge Rivlin in this case. it is often difficult to speak in terms of fault. The dissolution of marriage is the result of complex circumstances, and adultery in itself does not make one of the spouses solely at fault. It seems that this is the only argument in the Israeli court's decisions for not weighing extramarital relationship in property distribution. The sub-argument: divorce proceedings are determined by religious law, in which fault is a primary consideration, as we all know. However, the issue of property is determined by civil law, which differs from religious law in this regard. Civil courts recognize that extramarital relationships are given significant weight in divorce proceedings, and a particular remedy is provided to the party who was harmed. So the courts, the civil courts, viewed themselves as exempt from compensating for that harm through the property distribution proceedings. Because of that, they took out the fault from property distribution and didn't want to punish the one who was adultery. However, aside from religious considerations, it is worthwhile to examine the modern rationales for joint property. In early decisions, courts based the joint property rules on a contractual rationale, setting forth an implied agreement between the spouses. It based on both economic and psychological logic, assumes that spouses who conduct a normal marital life, in which each contributes to the family effort, would agree on a joint property arrangement. Is the contractual rationale indifferent to an extramarital relationships? One may assume that an important factor, such as extramarital relationships, would impact not only the content of the property arrangements, but also its very existence. Spouses who do not have a normal marital life will not be willing to deepen their commitments by creating an economic joint property relationship. When the contractual rationale is the theoretical basis, it seems very difficult to establish full property sharings, for the great majority of people will not agree to share their property with their spouse if they know that their spouses are breaching their trust. An affair could very well be considered a fundamental breach of contract that entitles the injured party to cancel the contract. The limitation of the contractual rationale motivated the courts to adopt the proprietary rationale. It led to a focus on the element of joint effort, and this focus brought the joint property rule closer to a sort of statutory sharing regime. Eventually, the joint property rule began to reflect the law of trusts or equity. It is based on concept of equal distribution, making fault ostensibly less relevant. But the joint property rule in Israel is the result of deeper theoretical basis. In the early 1980s, values from property law, especially the value of labor, began to penetrate the marital property laws. In the factual economic reality, both spouses contribute joint efforts to producing and improving family property. So this property should be awarded to each spouse. The labor theory impacted the transition of the joint property regime from a regime based on consent to a regime originating in the law. The right of a spouse in joint property is reward for that spouse's contribution in creating the property. It may be argued that the term contribution in a broader sense relates not just to the couple's economic relationship, but to the emotional aspects of the relationship. When quantifying the contribution of each of the spouses, one should consider also the contributions to the existence, preservation, and development of shared married life based on trust, loyalty, and love. This understanding of the term contribution will allow for consideration of sexual fault in determining property distribution. Second, a review of cases law from the 1990s demonstrates that the courts based the joint property rule on principles of justice and fairness, not only labor, but also justice and fairness. It opens a significant door to waning sexual fault in determining property distribution. A review of Israeli case law shows that in shaping the context of the joint property regime, the courts adopted a narrow conception of the word justice that relates only to economic fault. However, the value content of the term justice allows for adopting its broader meaning that also considers a sexual fault in determining property distribution. The third value is the equality. Equality means treating equals alike and treating those who are different differently. And in an unequal property distribution actually fulfills the substantive equality and does not harm it. Joint property includes the sharing of obligations and debts, except for obligations made in breach of trust. For example, for the purpose, case law reveals that there are different types of obligations. Obligations that harm the foundation of the marital relationships are not included in joint property. Different fields of law and extramarital relationships. In the Court of Appeal, an anonymous case, Judge Rivlin raised the difficulty of examining emotional relationships from the contractual perspectives. In his opinion, there should be no compensation for emotional harm caused by adultery. Indeed, he said, the law does not stop at the entrance of the family home, but the law abstains from trying to settle emotional relationship. Professor Tedeschi writes that there are no sanctions under Israeli law against the adulterous spouse, except for religious sanctions. One of the considerations in American law for not weighing fault in property distribution is the availability of bringing a claim under tort law or criminal law. In Israeli law, no such availability exists. C. The moral argument. In the Court of Appeal, anonymous case, Chief Justice Barak stated, even the aversion to an extramarital relationship does not reflect the approach of today's society, and the common law marriage principles will prove it. These words contradict the statement of some American legal experts who argue that even in modern day society, the majority of the population is averse to extramarital relationship. Proposal for a new model, the dominant cause model. And this is the end of my election. When the totality of the evidence shows that the extramarital relationship is the dominant cause of the dissolution and disregarding it, the marriage was stable, then the extramarital relationship should be weighed in property distribution. That will provide protection to the spouse who was harmed and will grant that spouse a greater portion of the property than he or she would have received in customary distribution. Furthermore, the spouse who has an extramarital relationship will not be allowed to claim joint rights in the external property of the other spouse. It means if he brought it before the marriage, the adulterous spouse cannot take part of it. I do not have clear response for all the questions that might raise. How much percent the adulterers will lose, and etc. Questions like this. But note that the lack of considerations of extramarital relationships also raises significant difficulties. The problematic nature of evaluation does not lessen or nullify the right of the injured spouse. In US, states that consider fault in property distribution also consider it in determining the amount of alimony. However, thank you, even states that do not consider fault in property distribution compensate the spouse who was harmed. This mechanism does not exist in the Israeli legal system. Alimony payments are controlled by the religious law, under which obligations for support terminate with the divorce. Therefore, the need to consider fault in property distribution is even more essential in Israeli civil law. Thank you for your attention.